Hello everybody and welcome back to our case summaries. In this video we're going to be talking about a case from the law of trusts. I've also enclosed a number of subtopics that this case essentially asks us to consider. So talking about the distinction between trusts and powers, the discretion that may be had, as well as fiduciary relationships as well. And this is the case of Mettoy Pension Trustees Limited versus Evans from 1991. Just like with all of our case summaries, what we're going to do here is talk about the facts of the case, talk about the issues that have arisen as a result of the facts of this case, and then talk about how the court approaches coming to a judgment in this case, and examine why this judgment is so significant. So, the facts of this case involved a pension fund scheme, a very particular pension fund scheme, where if there was an additional surplus of funds, then this additional surplus of funds would be able to be applied, or at least could be applied at the discretion of the employer. So this was a scheme that had taken place under the ordinary solvent running of the corporation. There was a fund scheme whereby a pension fund would continually increase in terms of its value, and if there were any other additional surplus funds, it could be applied at the discretion of the employer. When it came to the point where the company shifts from solvency into insolvency, the company goes into liquidation, the benefits of this surplus stood at around £9 million. Now, for anybody who has any kind of experience in company law or insolvency law, or specifically the idea of law relating to insolvent liquidation, you will know straight away that one of the things that happens when you go into when a company goes into liquidation is that there has to be a distribution of assets to the secured and then ultimately eventually to the unsecured creditors. And what in liquidation essentially involves is taking a very long list of creditors in a lot of circumstances and trying to distribute assets among them in an order that is equitable and essentially is beneficial to said creditors. And so when you have this fund that's lying around that's worth £9 million, this could be potentially very useful for a liquidator to have their hands on so that they can essentially be able to use this money to distribute to creditors who are in need of payment of their debts at the point of liquidation. So when this went to court, there were two major issues that the court had to consider, i.e. whether or not the beneficiaries were entitled to discretion under this particular system, i.e. whether or not the power in question was a fiduciary power. And then secondly, whether or not the exercise of this power is something that could be done and could be performed by the liquidator in the process of insolvency. So when insolvency takes place and when liquidation takes place, a liquidator will be appointed, an independent third party, neutral third party, who will go about essentially distributing the assets and breaking the assets down for the creditors who are firstly secured, and then if there's anything left, those who are unsecured. Now, it was held that in answering the first question, it was concluded that the power was fiduciary, and so the beneficiaries had discretionary rights to this particular property. And then in the second question, in answering the second question, the question about whether or not the liquidator had authority, it was claimed, or held, should I say, that the liquidator did not have authority to exercise the power since the assets weren't actually held by the company. And so instead, the power was able to be exercised by the courts. And so the courts were able to exercise the discretionary rights for the beneficiaries of this trust fund, not the liquidator.